Hi everyone, I am here with Jeanette from Onyx Legal. Jeanette, would you like to introduce yourself?
Certainly, thanks Ellie. Jeanette Jifkins from Onyx Legal. We are a boutique law firm situated in North Lakes and we work with people all around the country. We have a background working with people in health services space, so understanding some of the things that you're facing.
So Jeanette, for a healthcare professional, what are the real risks that they face if they don't comply with industry regulations?
Well, the biggest struggle for health professionals is being struck off. You lose your whole ability to earn your livelihood and to apply your professional experience to what you want to do. So it's very important to have an understanding of what the compliance and the regulations are. And also in terms of actually having to deal with regulators, if a complaint is made against you or comes to the attention of the regulators, that can be a very long process. And often for people it's over a year. So that's a huge distraction for you in your business. It's a stress, it's a cost, all of those sorts of things. So you really, it very much helps to be aware of your regulations and how you're going to comply with them.
Do healthcare professionals need to comply just with AHPRA, or are there other regulatory bodies that they need to comply with and consider?
In most states and territories there's another layer of compliance. So for example, here in Queensland we have the Office of the Health Ombudsman. So most health complaints first go to the Health Ombudsman, who looks at them in respect of their actual regime, and then they get referred to AHPRA if there is a specific AHPRA issue. Now the difference between the two is that we call him it's now a her, we call the Ombudsman an OHO, because it's the Office of the Health Ombudsman. So in Queensland the OHO has more power, so they regulate all the unregulated professions. So AHPRA has the 14 that they look after. Everybody else who offers a health service is covered by the OHO. So if a complaint goes to them, then they have the power to do something about it. In New South Wales, it's the AHPRA, and again, it's a similar sort of regime where they have additional things that they can do to stop people practicing.
And what about patient privacy? Is there any concerns around that or any compliance in terms of patient privacy?
Absolutely. For patient privacy, so the Privacy Act applies to all health professionals. It doesn't matter what size of your business. So normally you may or may not be aware that small business, which is defined as a business earning less than 3 million a year in revenue, is not required to comply with the Privacy Act. However, if you collect health information, you are required to comply. So every health practitioner should have a privacy policy, should understand how they're dealing with personal information and have processes and procedures in place to manage that.
Are healthcare professionals allowed to promote an offer for their services? And if so, how do they do that compliantly and ethically?
Okay, so there is nothing wrong with making an offer to get clients, either new clients or repeat clients, to access further services. However, you do need to do it carefully. So you can't be seen to be misleading consumers. You can't be, you can't use like bait and switch, which is where you offer them something for the purpose of upselling them to something else. You have to be very clear on what the terms and conditions are. So if you make an offer, for example, on a website and you say for this week, you get 2 services for the price of 1, whatever conditions you put around that, say for example they have to make the bookings that week and they have to take them up within 2 months, something like that, those terms and conditions have to be very clearly stated with the offer so that your client has the opportunity to read them through and understand them before they make a decision whether or not they'll accept the offer. So provided that it's compliant with consumer law, which is not misleading and deceptive, doesn't make any promises you shouldn't, doesn't have any costings that are non-compliant with consumer law, all of those sorts of things, and the terms and conditions are clearly stated and aren't designed to sort of lure someone in inappropriately, then you can make an offer. You also need to be aware that if you're making an offer, so there are hubs of services where multiple practitioners work together. If you're making a multiple offer across services, you need to be very clear that what applies in regard to each different service and who's doing what and how people pay, all of those sorts of things. You've got to think those processes through and make sure that they're very clearly articulated in the offer.
And then with an offer, if we're putting this in a Facebook ad, do we have to put all of the terms and conditions in the Facebook ad itself, or can that be on the landing page?
So all the terms and conditions can be on the landing page, provided that it's very clear there are terms and conditions. So much like TV advertising or radio advertising where they say terms and conditions apply, you've got to have that obvious link. So the Facebook ad would have to, in the visible part, before anybody clicks on it, have to say that, see our terms here, or terms and conditions apply, just so that people are very clear that the offer by itself isn't standalone. You have to have a look at more information.
And in Google Ads, I know we do that a lot, where we have T's and C's apply within the Google ad, and then the rest of the terms are on the landing page. So we get a lot of questions around Google reviews. Can you have them? Are you responsible for removing them? So what is the stance on Google reviews? Can a healthcare professional have them? And if so, is there a compliant way and a non-compliant way?
The only compliant way is that you can have star ratings, but you can't have any commentary. So the very challenging thing you have with Google reviews is you can't do anything with them once they're there, and that could potentially make you non-compliant. Your only option would then be to remove all of your Google reviews, which for most people is just, it's not a process. Yeah. So you need to be very careful about educating your clients as to what you can and can't have in terms of Google reviews. So you can say to them, look, we'd really, if you'd like to give us any feedback, we'd be really happy if you could give us a star rating, but please be careful not to write anything, because that's considered a testimonial, and we can have to answer to the regulator for that, because under the legislation, and believe me, when the draft legislation came out, I put in submissions against this. Under the legislation, you can't have testimonials, and anything really in writing about the service, the health service you're providing, is considered a testimonial.
So Jeanette, with marketing, a lot of the time if we do storytelling marketing, so actually, telling about someone's story before treatment and after treatment, that can, I guess, really resonate with the audience and make a really successful marketing campaign. But how can a healthcare professional make that compliant? Are they allowed to be doing case studies, and can we be doing storytelling marketing in healthcare?
Certainly. So you can do case studies, and that is one of when you read a lot of the AHPRA guidelines, they talk about case studies being acceptable, but it's the way in which you do them. So you can talk about this individual and this individual's circumstances, and of course you would obtain from that individual all of their permissions first. You talk about what their experience was specifically, and as long as you're not making any promises about you can get the same results, that kind of thing, that you can't do. So you can only talk about this individual and their experience and what you help them with. It's better not to be very specific about the services that you provided. So you provided chiropractic services, that's fine. You wouldn't explain what, how you manipulated them, or what exercises you gave to them, or, you'd be more general. We gave them exercises to take away and do at home, that kind of thing. You generalise the services that you've provided, and you take the individual through their personal experience. And as long as you're not making promises that other people can get the same results, or that in actual fact this result was better than they could obtain from anyone else, don't do that. That's not good.
And that applies to video and like a written case study and everything.
Absolutely. Yeah.
Great.
And it's a really good idea. If you're ever concerned about anything like that, get it checked. Because it's very easy with video. You can edit out little pieces that you need to. With written material, from time to time we review whole websites for health practitioners because they're concerned about their compliance. And often it's, one word here, one phrase there, little things that could potentially be a challenge for them. We've taken clients through the whole process of having to respond to AHPRA on concerns. One of our clients was told their whole website had to come down, which is just not practical. You've got to remember that regulators are looking at it from the position of this is what the legislation says and we're trying to protect the public. They don't actually then take the next step of saying, is that a practical request or does it make sense for that business? Because their main driver is how do we protect the public. So yes, sometimes it is really worthwhile having someone work through the process with you and check all of those things just to tweak, possible problems. Now, that's not essential for everybody. I don't want people to panic or stress. But if you do have concerns, get peace of mind.
And I'm going to endorse you a bit here. Jeanette is a really great and trusted resource as well. So if you do want to do more of this storytelling marketing, then I would recommend coming to Jeanette and just talking through what the case studies might look like, or even getting Jeanette to look over them. So
thanks.
Social media is about two-way communication. So if a patient comments on a Facebook post or they send you a message on Messenger, can you actually respond as a healthcare professional, or do you just stay silent and leave that comment to be?
It really depends on the comment. Where somebody is blatantly wrong, so I get this from a legal perspective, helpful people on social media trying to advise other people with no experience, and where they're blatantly wrong, it's okay to say that's not evidence-based and you should seek further advice from a professional. But a health professional should never give specific advice in response to a comment on social media. So general responses that it doesn't meet evidence-based, or that's not your experience, or recommending that they go and see someone, those sorts of comments are fine. But don't ever be seen to be providing a health service through social media because it's public. And you'll be in breach of your privacy obligations. So yeah, I always suggest to people, when something gets you fired up and you really want to respond and be involved, write the response but not where it can be posted. And then think about it, and then you have the opportunity to edit it before you put yourself at risk. So yes, it's okay to engage on social media. You just need to be aware of how you're engaging and whether you're overstepping the line in terms of providing a health service or being potentially controversial. Don't ever comment about other practitioners. Yeah, there's some common sense things you should put in place.
And then I guess general customer service is okay. So if people are asking about opening hours or events or whatever, that's all okay to respond, because
that's fine.
Some people are still worried about that. Even comments,
comments. Anything where you're just letting people know the general information about the service they can access. Even costings, if people ask that, I would personally do it on private message. But those sorts of general comments you can engage on social media. It's more the falling over into health services and overstepping the mark.
So chiropractic care can help with a lot of different aches and pains or issues within the body, but how do you portray all of this if you're a chiropractor to a patient? Like, what are the rules around this? Can I just say, I can cure asthma, or I can cure back pain, or throwing the wild ones out there?
Absolutely. You can't cure anything. It's just, don't use those words. So the AHPRA guidelines specifically say if they see the word cure in anything, it's a red flag to them. So if you want to use that word, you are immediately bringing yourself to the attention of the regulator, whether it's you who does it or somebody finds it and complains about you. So you can't cure anything. But evidence-based suggests there's heaps of things chiropractors can help with. So can assist in resolving these issues, can assist in improvement. So those sorts of general expressions you can certainly use, and be very aware of the potentially political environment that you're in at the moment. I know that the Chiropractic Board is currently reviewing, in particular, infant chiropractic. So at the moment, I think there's a ban on advertising any chiropractic for an infant under the age of 2 years. You need to be aware of those things. So they're posted on the AHPRA website as, you know, particular things of interest to that board at the moment. You need to be on top of that, and, you know, just as part of checking your registration online, if you're visiting the AHPRA website, check the specific chiropractic board areas of importance at the moment, or what they're investigating, and just make sure that you don't stray into those areas, because it's just not worth the risk. Dealing with the regulator is hard work and stressful and expensive. So if you can make your whole life easier by just paying attention, then please do it.
And when you mentioned don't say the word cure before, I know safe and effective is two other words that you can't use across the healthcare profession, and a lot of the time we'll use like may help with like back pain or neck pain, actual evidence-based results for chiropractors and what they can and can't do.
Yeah, that's right. There's plenty of ways you can say what you want to say. You just don't want to be taking it to the extreme.
So we, as a marketing agency, do a lot of online research as to, you know, what chiropractors are saying and what healthcare professionals are saying overall. We do come across a lot of chiropractors and other healthcare professionals, particularly in allied health, that say, you know, and again, I'm coming back to chiropractors. I'm a chiropractor that specialises in sports chiropractic. Can I say that? Can you say that as a chiropractor?
You need to be aware of what the actual requirements are around specialist registration. So my stronger background is actually in psychology. I was on one of the AHPRA psychology boards for 6.5 years. And in psychology, there are 9 specialities. And if you have qualified and become registered as a specialist, then you can say you're a specialist in, say, health, community psychology or clinical psychology, those sorts of things. And if you haven't got those qualifications, you can't say you're a specialist. So with chiropractic, it's the same. You need to be aware of what levels of registration there are and what you're allowed to say and not allowed to say. And generally speaking, in the regulated professions, you can't use specialist. So even though we as a firm in the legal profession do a lot of work with people doing business online, we can't say we're online specialists, because it apparently creates an expectation in the public that you have skills over and above everybody else, and you're not allowed to do that unless you actually have a registration to back it up. So with chiropractic, you can talk about, you know, it depends on your business and what you feel comfortable with. So from a business perspective, I talk about it as a risk profile or a risk appetite. So how much risk are you prepared to take? Are you prepared? Do you want to be completely compliant and never have an issue with the regulator? Then you would be more conservative in the way you express yourself. If you're prepared to push the boundaries and maybe hear from the regulator, then you might talk more about things that could be, you know, on the border of what the regulators may be interested in, and ask for forgiveness later, you know, go through the process of correcting what they want corrected. So it depends on where you are in your business and what you feel comfortable with as to how far you go. And then when you do talk about more general, you know, health and well-being, make sure you have the evidence base to back it up. You know, and yes, that does mean you have the scientific papers and you have the research and all of that sort of thing sitting there in a file that you're able to present if you're ever challenged.
So Jeanette, thank you so much for giving all this information to the audience today. I know there are a lot of questions when it comes to AHPRA and for chiropractors, and I know you've just covered a few of them. So if you have any more questions for Jeanette, where can they find you? How can the chiropractors reach you?
Absolutely. So you can contact me on advice at onyx.legal. Onyx is Onyx. By all means, drop me an email. You can find me on social media. We do have a Facebook page, and our website is currently onyxonlinelaw.com, and very shortly will be onyx.legal. We're working on it. So yes, by all means, drop us a line and we'll be happy to help you.
Thank you.